morning, ladies and gentlemen. I think it's time for us to start the discussion. Welcome at this session and what I believe to be a most interesting and pertinent discussion on the topic of data protection.
Please turn your cameras on, guys. The session is live now.
My name is Pierre Coetzee. I'm the Chief Legal Officer at PASA. I joined PASA in 1999. But let me introduce my panelists, starting with the expert Ira Gunning, an executive at ENS Africa. She's an ad hoc lecturer at WITS and a POPI and a data expert. Our next expert is Dr. Ina Meiring, Senior Legal Counselor at PASA. She was previously at ENS Africa, Worksmans, and ABSA. She has a doctorate in payments from UNISA. Our last expert colleague is Kagiso Mothibi, Head FinTech and Innovation Hub at the FSCA. He was previously at the Vodacom, and he has an MSc at Oxford University and MBA at Gibbs. Now, in the Open Finance Consultation paper, the Financial Sector Conduct Authority said that data and technology are transforming the financial services sector in South Africa and across the globe. So we see two elements playing out, data and technology. In this context, the panel will be requested to consider whether data protection enhances or prohibits efforts to build a future payments system, or even for that matter, run the current payment systems. A payment system, as we all know it, is an end-to-end ecosystem comprised of multiple entities, participants, and including consumers. A payment system, therefore, is based on platform, and as we know it, interoperable payment system. Through the platform, connect many people where huge amounts of information or data are processed. A payment, on the other hand, is initiated by a customer of a bank or a third-party provider by giving an instruction to the bank or such provider to process the transaction. This is what we call the mandate. We have a mandate, we give the mandate to the bank. So the processing of a payment transaction is generally based on consent. Again, it's very important to keep that in mind, given by the account holder. But in exceptional cases or situations, such content becomes critical in, for instance, reversals of duplicated transactions or reversal of a payment into an incorrect account. What do you do and how do you reverse that transaction? Consent also applies in other areas like open banking and open finance, but we will discuss that by the panel. Information or data is critical in the payment system, starting with a bank-client relationship where the bank would sign terms and conditions with the customer. The processing of a payment contains a lot of information, as we've seen in FATF, and it contains certain elements that must be incorporated into that transaction to be able to process it successfully. So in a legal sense, many colleagues will understand this. We say information or data with a payment transaction is a sine qua non. What we mean there, it's indispensable. You cannot process a transaction without information. Now, we know in South Africa, we have promulgated the Protection of Personal Information Act. The FSCA has issued the consultation paper on open finance, and the SARB, the consultation paper on open banking. The UK and the EU, they have issued the PSD2 document, and I think they're the front runners as far as data protection is concerned, and open banking and so on. So we also need to remember and keep in mind the requirements by FATF about information, population of a transaction with necessary information. So with the above in mind, I would like to request our expert panel to share their insights from their areas of expertise. In considering panel members, I request you to consider the main principles in payments, the principles in information sharing, data protection, and so on, the goal, the purpose, the applicable data that we should look at, the policy objectives in most instances would play out, as well as the balancing act between the benefits and the risks that we are seeing. Now, pieces of legislation coming to mind, PIA, the COFI bill is going to be applicable as well, Consumer Protection Act, and of course, POPIA. What are we solving for? I am posing my first question to our expert, Ira Gunning. And Ira, the question is, would you be able to provide just a brief overview of the Protection of Personal Information Act, and how does it impact the payment system? In what sense does it impact the payment system?
Thank you so much, Pierre, and thanks for this opportunity, and thank you so much for everybody for joining. POPI or POPIA, the Protection of Personal Information Act, is certainly my favorite topic, and I love it because it just applies to absolutely everything, certainly to the payment environment. So POPI is triggered when we process personal information, which is entered into a record, and generally the rule is that it happens in South Africa. So it certainly affects everybody in the payment space. And Pierre, I liked you referring to the sine qua non test. It took me back 15 years ago when I used to lecture Commercial Law 101 and the but-for test. And as you mentioned, we need data in the payment environment. We need data in the national payment system. And that data is often personal information. So if you are dealing with information that relates to an identifiable human being or an identifiable juristic person such as a company, and you collect that information, you store that information, you transmit that information, you disseminate that information, you destroy that information. Anything that you do with that data in the payment environment would be seen as the processing of personal information. And of course, it is entered into a record in the payment space. And that triggers the application of the Act, which means that every single participant in the space would have to comply with POPI. Now, of course, your duties and obligations would depend on whether you are a responsible party or an operator. But of course, POPI comes with a whole host of obligations. Specifically, you have to comply with the 8 processing conditions. So we can't just tick one box and say we're keeping our data secure, so we're POPI compliant. We have to comply with accountability, transparency. We must tell the data subjects what we're doing with their data. Of course, we must keep their data secure. We must attend to data subject access requests, and so on. So yes, we have to comply with the 8 conditions of lawful processing, and then if we send that information overseas, the transport or transfer provisions kick in. If we want to do direct marketing, that is regulated in terms of POPI, and so on.
Thanks a lot, Ira. Let's explore this, because the National Payment System Act makes provision for a PCH system operator and a system operator, but the POPIA also refers to an operator. And we need to distinguish and differentiate between the two. Is there a specific role for a PCH system operator in regards to POPIA as it plays out?
Yes, of course. In my view, the PCH system operator would be acting as an operator in certain circumstances, but it could also be regarded as a responsible party as contemplated under POPIA. And perhaps Ira could elaborate on that. A system operator is an entity providing services to two entities, payment services. Yeah. Now, this is not the definition of an operator under POPIA. So the problem is that the system operator could be regarded as an operator for purposes of POPIA, and then different considerations will apply. Ira?
Yeah, absolutely, Ina. So I think let's start off with what is the difference between a responsible party and an operator in terms of POPI. A responsible party is also called a data controller overseas in the context of the likes of the GDPR. So a responsible party is that entity who decides we need personal information, we need it for a specific purpose, and we're going to collect the following personal information. They are in control of the data, and they are responsible to comply with POPI in respect of the information. But POPI recognizes that the responsible party can't do everything itself. So often it would have to use a third party, an agent, a non-employee, to do stuff with the personal information on its behalf, like sending payment messages or storing data in a cloud. So that third party does something on the instructions of the responsible party with that personal information. It could, for example, have the technical know-how, how to do it. It could be a technical platform, or like I mentioned, a cloud or something like that. But the main thing is the responsible party is the person who's responsible to keep that data safe and so on. So if you hand over your data to an operator, it is like handing your child to a babysitter. You want to make sure that it is going to be looked after. So you suppose, as a responsible party, to do some sort of due diligence on your operators, and especially their security features, to make sure that they're going to look after the information. What is interesting in terms of POPI is an operator only has 3 duties. Keep information confidential, don't do anything with the personal information that the responsible party isn't aware of, and if there is a breach, tell the responsible party. So your operator, and if they breach all 3 duties, there are no penalties in terms of POPI. So very light regulation for our operators in terms of POPI, and they're seen as the arms and the legs of the responsible party. So if there is, for example, a data breach at the operator, they only need to tell the responsible party, and the responsible party needs to go tell the regulator and the data subjects, and would be liable if they didn't have proper security measures in place. So crucial in the NPS system to identify who are your responsible parties and who are your operators. I agree with you in a completely, your PCH system operators usually seen as data processors or operators. Of course, they can wear 2 hats, because when it comes to products that they directly offer to individuals or to their employees, they would also wear a responsible party hat. But when they do that processing of data in the payment space, they're usually seen as operators. When it comes to system operators, I find something quite remarkable. If I look at the international standards, if I look at privacy policies overseas, I see very often the system operators are classified in some circumstances as controllers or responsible parties, and some circumstances as operators or processors. What are your views on that? Do you see our system operators in South Africa as operators as well in the POPI context?
Yes, I would agree with that. And the other entities that are also regulated under the National Payment Systems Act, third-party payment providers. Now, they are defined as persons who make payments to other persons as a regular feature of its business. And of course, they will be processing data on behalf of the party on whose behalf they pay. So you could have a payer service provider or a beneficiary service provider. Only requirements must be under the National Payment Systems Act, that it must be a regular feature of your business, and that you must make payment to multiple beneficiaries or multiple payers on behalf of beneficiaries, or at the other side, a beneficiary service provider. So here again, you would have to critically look at what exactly is being done by a TPP in order to determine whether they are regarded as responsible parties or as operators. And as you know, under POPIA, so if we are correct in saying that a system operator and or a TPP can also act as operators as contemplated under POPIA, then additional requirements are imposed on them. And you know that that's the written agreement that must be entered into, and that written agreement must contain certain clauses. I don't know whether this has been recognized as such at the moment in the payment industry.
Yeah.
And just to add to that, I also see sometimes with the TPPs, I think very often they would act as a pure operator, but then they also want to market their services directly to data subjects. Of course, you can't be an operator and then say, but these are my customers, because if you're an operator, it's the responsible party's customers. Otherwise, you're probably dealing with a some sort of joint responsible party or co-responsible party relationship. So just for the audience out there, this certainly is a factual inquiry here as to whether you're acting as an operator or responsible party, and certainly would have an effect on your marketing initiatives as well.
Yeah.
Colleagues, very interesting discussion, I must say. And when we talk about PPPs, system operators and PSOs, the same thing would apply to banks. A bank, by its very nature, acts as a system operator. And so many, because the client is also the client of the bank in most instances. But let me change the subject ever so slightly. I would like to go to Kagiso. And Kagiso, the FSCA issued the Open Finance Consultation paper quite recently, and they made a few recommendations in that paper regarding reference to consent and customer protection and data protection. Do you agree with those recommendations? And maybe can you elaborate on some of the recommendations made in the Open Finance Consultation paper?
Sure. So essentially what informed this paper was the increase in the data sharing that's taking place in the financial sector, and that being what drives propositions that are being offered to customers. So that kind of meant that as regulators, we obviously had to take note of that trend and ensure that customers are being treated fairly throughout. And so from a benefits point of view, some of the things we obviously recognized was the fact that there is the potential for financial inclusion. Through data, you're able to better understand your customers and therefore include customers that would traditionally not be included. So we recognize that aspect. We obviously recognized the fact that personalization and addressing needs very specifically can be achieved through this data sharing. Customer experience and convenience can be improved, and also ultimately pricing and affordability can also be achieved through all this data sharing. But simultaneously, there were a number of risks that were unaddressed in the market. So we obviously had to put together a proposal as to how to address these risks. And some of these risks include the insufficient customer education in order for the customer to be able to give informed consent. And this customer education has to be tailored to the specific financial service, because data can be used in different ways depending on what the financial activity is. So that was the first area of concern. To what extent are financial services providers informing their customers, and to what extent is it fit for purpose for the financial activity they're engaging in? Secondly, it's just around the transparency. So once you've obtained consent, to what extent are you able to be transparent with the customer around how you continue to use that data? How do you maintain and sustain informed consent? So that was the second piece that we wanted to open a dialogue with industry around. The third piece was then around data protection and really just leveling the playing fields. So when you share data with third parties, to what extent is consistency of data protection standards upheld? To what extent is there interoperability and the customer can trust that when their data passes hands, it is still secure? And then also there's the issue of how data is used. So, and this is more a data ethical issue. To what extent is this data being used to potentially create bias or discrimination for customers? How are algorithms being applied? Do financial service providers understand these algorithms? And then there was also an issue of data misuse, so exceeding the scope of the consent given by the customer. So to what extent does that happen? To what extent can that be safeguarded? And then lastly, also just around dispute mechanisms. To what extent can customers dispute any use of their data that they may have, and to what extent can financial service providers be held accountable? So that was a lot of the themes that we wanted to open a dialogue with industry around, and really solving for ensuring that customers are ultimately treated fairly in how they are engaged with through their data. and that obviously financial institutions are conducting themselves in a way that ultimately protects customers. So those were some of just the themes that we wanted to have a dialogue around industry in order to ultimately put standards in place that that facilitate a safe and secure open finance framework.
Kagiso, thanks a lot for your feedback there. And I really enjoyed reading the paper. What I saw from the paper is, and again, I want to emphasize the 2 points, is data and technology. And that's what we're seeing playing out in this environment. Data is not new, but it's the ability to process huge amounts of data these days in many ways that we can store, process, pass on, and so on, and what we do with the data. And what we see in open banking is definitely going to be a benefit to the consumer, but also a benefit to the third-party provider. Now, in both instances, as you said, and we need to keep that in mind, there's also a risk. There's a benefit for both and a risk for both. And ultimately, we need to look at a proper framework in South Africa. Can I just ask from an FSCA perspective, are you planning to introduce a compulsory framework like we see in many of the countries that you assessed?
So we put out a consultation paper, and I think the idea is to engage in a collaborative process with the industry in order to ultimately create something that's fit for purpose. So we've been having workshops exactly around some of these themes. And I think the idea then is to ultimately come to some sort of consensus around what standards can we put around data sharing and what standards can we put around how customers are treated around their data, and to what extent do we recognize that ultimately the data belongs to the consumer and therefore that gives them rights over that data, and how can those rights be respected? So it's really coming up with a framework that's fit for purpose. It'll be more principle based than rules based, but I think it is something that we depend on collaboration with industry ultimately to come up with something sustainable. So I think that's the approach that we're looking to take. Because I think the industry itself, just given the pace of innovation around use cases, they play a critical role in terms of shaping how some of these regulatory frameworks will land. So I think we need that engagement and input to ultimately develop something fit for purpose. So that's kind of the approach we're looking to take.
Kagiso, thanks for that. I think what the industry also appreciates is the fact that our regulators issue consultation papers and include the industry in consultation and forming and shaping the regulatory framework for South Africa. And similarly, the Reserve Bank issued a consultation paper on open banking. And again, on a similar note, because the two are closely related, especially as far as the principles, the objectives, and so on are concerned. And what we're seeing and playing out in this consultation paper, screen scraping versus open banking, APIs, and so on. What's your view on the Reserve Bank's consultation paper on open banking, and taking into account that there are new developments like rapid payments, all these things, data being used to process in screen scraping, in any payment system, and also open banking. And maybe you can conclude with also the view of what the benefits of such an open banking system or framework would be, as well as the risks to consumers, but not only to consumers, but also third-party providers. And I'm using the term third-party provider to distinguish it from the concept that we know in the payment system as a third-party payment provider. So a third-party provider in these consultation papers is like a fintech. Any person or financial institution involved in the processing of open banking or open finance. Over to you, your views on that consultation paper with reference to screen scraping and open banking.
Thank you, Pierre. You're quite correct in saying that there are overlaps between the open finance and the open banking consultation papers. And this is my specific concern, and perhaps Ira could address this as well, is that the consumer protection that Kagiso is referring to is contained in POPIA. We need the regulators, the FSCA and the SARB and the information regulator to talk to one another in order to align all of the principles that need to be agreed upon to protect the data. Because we cannot talk about data protection and leave the provisions of POPIA aside. What has happened in with the second payment directive in the EU is that they required for the under open banking and certainly for open finance as well, they required explicit consent. But what they then did was issue a guideline to say that this explicit consent required from the customer for purposes of saying, yes, you can use my data to provide these services to me, is a contractual requirement and is not the same under the GDPR. And that's the type of guidelines that we need from the regulator. The other point I want to make is that the technologies addressed in the two consultation papers were screen scraping and AIPs. And there are obviously more technologies that need to be included in any discussion paper. And Ira, you know that my pet subject is automated decision making under the open finance paper. We need to discuss that, taking into account the provisions of POPIA, and not merely put this forward as a possibility of providing another type of service to the client. Now, both the screen scraping and AIP consultation issues, or the issues that are the same under screen scraping and AIP, is obviously, as we've agreed now, it's the protection of data. So that introduces two types of financial services, new financial services, account information services, and therefore account information service providers, and a payment initiation service provider. Those were the two concepts introduced by the second payment directive, and it seems to me that in especially under open banking, that the SARB is leaning towards introducing these two as third-party providers under the National Payment Systems Act. Now, the benefit of that is obviously open banking. It's inclusion, but there are risks involved. And the risks could be addressed by saying, same activities, same risks, same rules. And therefore, I'm in favor of regulation for everybody, so that not only the banks are regulated, but the other role players, the third-party payment providers, are also regulated in this space. The other issue too is, the definition of a payment initiation service provider sounds almost like a teachable P. So, we would need to distinguish exactly who's who in the zoo. Who's the third-party payment provider and who's going to regulate this? And Pierre, you did a lot of work under Coetzee. A payment service provider, it seems that they are going to be licensed by the FSCA, but they're also going to be regulated by the SARB insofar as they form part of the national payment system, whether by means of rules or prudential regulation. And this is the difficulty we now have in distinguishing between these two types of services and who to address this with the FSCA or with the information regulator or with the SARB. I missed a lot, but can we stop there and ask Ira about
Yeah. Thanks, again, very rich in context and information. My question to the panel as a whole is, what we see playing out, usually regulators would look at policy objectives like financial inclusion, safe and sure, secure payments environment. The FSCA consultation paper goes as far as to say financial stability. Now, financial stability is mentioned in the Financial Sector Regulation Act. And one would think that financial stability is really a prudential authority responsibility. But it's interesting to note that if there is an impact and lack of trust in a payment system where information is compromised, then that could result in financial instability. Now, I don't want to preempt. What is your view on the role of policy objectives like innovation, like competition, like financial stability, consumer protection, all these in an environment where we are dealing with technology, but have to process a lot of data? Kagiso, maybe I can start with you as a regulator and then go to Ira.
Yeah, sure. So from our side, sure, well, we definitely see that within the context of open finance and open banking, that there is strong customer elements, but we also cannot ignore the other elements that are also present. So the competition dynamics, the financial stability / prudential dynamics as well. So those are things that we recognize, and hence why, from an IFWG perspective, which is Intergovernmental FinTech Working Group, we have all these stakeholders involved, and this also is extended to information regulator, so that we can actually create alignment around how we are thinking about open banking and open finance and all the various aspects. And then the second piece, so that we actually also not only understand the primary risks, but also understand the secondary and tertiary risks that could emanate from an open finance framework. And so obviously you also have Treasury there as well. So they are there to obviously provide input from a policy imperatives point of view. What would be the benefit to the country and the financial sector for having an open finance framework? And obviously policy imperatives like financial inclusion come up quite a bit as well. So those are the discussions that we've been having as a regulator. So it's not a single regulator journey, it's been a multi-regulator journey, as well as with the competition authority, in order to ultimately align around our thinking in terms of approach on this matter, and also in terms of then responsibilities, so that there isn't any conflicts or overlaps. So that is kind of the approach. And so IFWG in general, that's what it's kind of, therefore it is a mechanism to tease out many of the policy and regulatory aspects that may overlap into different regulators, and to have a single place in which to have a discussion around this. So with fintech innovation in general, such an approach is very much key because, I mean, if you look at platforms as an example, they tend to be multifaceted in nature, and there's multiple financial activities typically underpinning them, and they even straddle beyond the financial sector. And so it was mentioned earlier that you want to level the playing fields, for instance, between what banks have to comply with and what other third-party service providers have to comply with. And so you need that kind of approach in order to be able to address those risks. And so authorities like Competition Commission, as well as Information Regulator, who also look beyond the financial sector, are also able to give input ultimately that allows us to manage a lot of these multifaceted dynamics. Thanks, Pierre.
Thank you, Kagiso. Ira, anything to add to what Kagiso just shared with us?
I'm very happy to hear that the regulators are speaking to each other, Kagiso, and I think that is absolutely crucial, as Ina said. And I also think that these third-party service providers should be regulated to some extent. Not necessarily same size fits all, but I think we need some sort of, going forward, we would need some sort of accreditation to know that our data is secure. So I think when we look at data protection, and I think, Pierre, you were asking whether data protection will enhance the NPS or whether it would stifle it. And I actually think it certainly will enhance it, because we want to trust our payment system, and we want to know what the payment system is doing with our data, and that will lead to financial stability. So from a data protection perspective, the three things that are the most important would, of course, be safety. We've seen with the data breaches, we've seen the data breach with the Department of Justice and the Information Regulator, cyber attacks really rife. So we need to know that our data is secure, and whether our data is in the hands of a bank or whether it's in the hands of a third-party service provider, we want to make sure that they look after our data. The second thing we want is transparency. We want to know, and Kagiso, that goes to your informed consent, and I really liked what you were saying there. We want to know what we're consenting to. And the only way you can know what you're consenting to is, for example, if you have a detailed privacy policy that sets out who's got your data, who will your data be shared with, what are the purposes your data would be shared for, so that we also don't have further processing that is incompatible with the reason for collection. And then, of course, data subjects' rights. They need to be able to enforce their rights. If somebody steps out of line with my data, use it for a purpose that I didn't give consent to without another justification. Of course, we don't always need consent. You were talking about reversal of payments, Pierre. If we rely on legitimate interests, or one of the exceptions to consent. But if there is no lawful basis for processing my information, then I want to be able to go and complain to somebody, and I want to know that I'm going to be heard. Data subject access requests. I want to be able to apply my rights and exercise my rights, make sure that I can check who's got my data. And it all boils down to what Steve Jobs said, and that's my favorite quote as far as data protection is concerned. He said, privacy is telling people over and over again what you do with their data. And I think that is just absolutely crucial.
Colleagues, thanks a lot. Ina, I'm not going to ask you to answer that question as well. I think our colleagues have responded quite well. But what I'm going to ask you is the following question. Have we answered the question whether data protection does, in fact, enhance or prohibit efforts to build a future payment system?
I think it will enhance it, provided that it's properly regulated. So in my view, there must be regulation. As I said, same activities, same risks, same rules. If that applies to everybody, then it should enhance the payments will.
Thank you, Ina. And I'm going to take that a step further, because and I think Kagiso is not only coming from a payment system perspective, he's also coming from open finance, or where any service from a fintech perspective is provided where data is processed. Now, Kagiso, my apologies for coming back to you. Would you support Ina's view that it's actually supporting the environment, technology, as long as there is secure, there's a proper framework, there is a dispute process and those things in place? It's not, the question is not as much, does it enhance or does it prohibit? I think, as we said, data protection is a sine qua non, is indispensable, because it's your right to your information. But let me go over to you, Kagiso. In a broader sense, do you think data protection would enhance future technology?
So firstly, I fully agree with Ina's points, and that's essentially what we're solving for, that that the ecosystem is very broad. So you want to make sure that there is some level of consistency in the ecosystem that the customer can rely on. So I think absolutely we agree with that principle. And yes, absolutely, data protection is very much part and parcel of how, or a key enabler to ensuring that fintech innovation is sustainable. Like, it is absolutely a critical part, because from our research across all the fintech innovations that are taking place, almost all of them are underpinned in some way by data. So data is being applied to various different things. Various use cases are being used through data. So I just don't see how the innovations are sustainable without data protection. and without making sure that there's consistency across the system. And so with open finance, the idea is obviously that the ecosystem is beyond just banking. There's other service providers that are handling customers' data. And so we need to ensure that standards are in place that protect the customer and ultimately ensure that the data is used for the purposes that it was intended to use, among other things. And I think Era touched on some of these elements quite well earlier as well, and fully agreed with the statements that she also made. That is also what we're ultimately solving for. So, Pierre, that's just my 2 cents around this.
Thanks, Kagiso. And I like the term you're using, enabler, subject, of course, to certain conditions. Now, colleagues, it seems as though we are supporting a proper framework for data protection, the regulators to engage the industry and to form an appropriate or proportionate light touch type of framework that gives certainty to the consumer out there that his data is protected. Now, that certainty will result in trust. Trust will result in a payment system or any technology being used, and ultimately coming back to financial stability. That will result in the upper level of financial stability. I would like to go now to questions. We have a few minutes. There's one question by Alicia, and she's asking, what will be the adverse effect, if any, to contract with another financial institution that is domiciled beyond the borders of South Africa? Now, Era, unfortunately, the question is to you. In a POPI sense.
No, I absolutely love that question, Pierre. I've been doing a lot of work in this space. So it's very important to know that POPI does have some extraterritorial effect. So if a responsible party is located in South Africa or domiciled in South Africa and it processes personal information, undoubtedly POPI applies. But if your responsible party is sitting offshore, domiciled overseas, and they do some sort of processing in South Africa that involves automated means, which basically means equipment, and if you go and look up the history of Article 4 of the old EU directive, it really is as much as touching any equipment in South Africa. A cell phone could even trigger those provisions. So if you are in any way processing data, including collecting data in South Africa, then that overseas entity becomes subject to POPI. So just important that you do know about that. And if you do enter into relationships, trans-border relationships, one thing that you must always watch out for is that these standard contracts define personal data as data relating to a human being. It doesn't include juristic person data. And of course, POPI includes juristic person data. So just always look out for that. If you ask to sign standard agreements, make sure you add a POPI addendum to that, and they should be aware of the risk of dealing with data in South Africa would trigger POPI, and they would have to have an information officer. They would have to have a PIA manual. I think these are all some unintended consequences of Section 3 of POPI, the application section.
Interesting. Thanks, Yera. I'm seeing that there are no other questions. I read a headline the other day, and unfortunately, I did not have the opportunity to read the article, but the following is playing out. China and their data protection impacting on South African consumers. Do you have a view on how this will impact on South Africa? And is this going to become a worldwide phenomenon?
Data protection is a worldwide phenomenon. And Pierre, that is why I'm so happy that POPI finally kicked in and became just about fully effective this year. So we can't run away from data protection laws. It's absolutely needed to enhance stability in the payment space and anywhere else. So yes, I just think it is a global phenomenon that we can't run away from.
Thank you, colleagues. I think we've come to the end of the session. Thank you for your input, audience, and ladies and gentlemen. Also, thank you for joining us. I think we can now conclude to the question that we posed in the beginning, namely that data protection would enhance any technology and future-proof payment systems in future. So whatever we develop, It is a sine qua non today. If you're not a legal person, you understand it's something that you cannot do without. Data protection is absolutely necessary for anything you do. It is a consumer right, and ultimately it's to the benefit of what we do in South Africa from a technological point of view. And on that note, thank you for your participation. And